Everyone, and thank you for joining us today for our Chartered Insurance Institute webinar with Flaxman Partners. I'm Catherine Kennett, Policy and Public Affairs Manager at the Chartered Insurance Institute, and I'd like to welcome you to our session on a statement of fact. Flaxmans are following up on past webinars on the subject of misinterpretation and non-disclosure by putting statements of fact under the microscope. Roger and Michael have a sack full of examples of poor and misleading statement of fact wordings, which they will present in the hope that this will lead to an improvement in standards of English, leading to less friction at the claims stage. We have with us online today Roger Flaxman, Chairman and Principal Consultant, and Michael Wilson, Director at Flaxman's Partners, who will delve into this topic in finer detail with you. There will be time for questions at the end of the presentation, so please feel free to use the question box you can see on your screen, and we work through these once this webinar is complete. So without further ado, I'm going to hand over to Flaxman's.
Good morning, and once again, welcome to our webinar. I'm Roger Flaxman, and with me, as always, is the venerable Michael Wilson. Now, as most of you will know, as particularly if you're regulars to our webinars, Mike and I spend most of our days resolving disputed and complex claims. Most of these come from policyholders and or brokers, and we do it either in the context of being advocates or as experts to the court. Never both together, you can't. But we've noticed in the last 3 or 4 years, a very considerable uplift in the number of rejected or disputed claims based upon an alleged failure to make a fair representation or fair presentation of the risk to the underwriter. Now, as you will know, making that fair presentation is a principal obligation under the Insurance Act 2015. And the question is, why has this occurred? In our opinion, there are 2 principal reasons. The first, let's just look at what the Insurance Act says. It says, and I'm just taking one sentence out of the whole thing here, the disclosure of every material circumstance which the insured knows or ought to know. Now, that is an incredibly broad obligation. And it creates a very fertile ground for dispute if, at the time of a claim, something is discovered by, I'll say the insurer, usually the loss adjuster, that was not recognised as being material at the time of making the contract, at the time of proposal. Now, the problem arises when a statement of fact is later produced for the insured, which appears to the insured or the policyholder, it appears to be a statement that confirms to the insured that the insurer has accepted the proposal and the information and is merely confirming what the insured has provided. So actually, it often reads as, well, that's fine, this is what you told us, and you've told us what we need to know. Now, the implication is that the questions asked in the proposal process have satisfied the insurer, but we know they haven't necessarily. Because what the insureds often tell us is that although they've answered the questions they've been asked, they haven't had any understanding or regard to the question of disclosure of every material circumstance which the insured knows or ought to know. And what insureds say to us is, well, if the underwriter wanted to know that, why didn't he ask more questions? Now, there is probably, and Mike and I are saying this with a combined, close on to 100 years of experience between us. We've been around a long time. There's probably nobody on the planet that really understands what every material circumstance which the insured knows or ought to know, what it means. And we know, from the amount of litigation on the subject that even the courts have to think about it every time they get a case put before them. So What the insureds do is they naturally rely upon the questions asked to them at the proposal stage. That's the first reason we think that there's a problem here. The second reason, which we're going to explain to you in some detail this morning, is that statements of fact are often very confusing and very poorly worded. Sometimes they combine a statement, I mean, the name on the tin, if you like, is statement of fact. So how can you ask a question? And that's the point. A lot of them are combined and they're not terribly well written. So in combination, the statement of fact, in our opinion, is causing more tension between policyholders and insurers than was intended by the Insurance Act 2015. And now we've got, 7 years of experience to show, 8 years of experience almost, to show what the unintended outcomes were. So Mike, over to you.
Well, thank you, Roger. As usual, we just need to look at the learning objectives. So it's to revise the insurer's duty of disclosure, to appreciate the difference in disclosure requirements between consumers and non-consumers, to understand the role of the statement of fact, to appreciate the difficulties caused by ambiguous questions and statements shown on the statement of fact, and to consider ways to improve clarity on the statement of fact. So that's what we're doing this morning. So sometimes those of us in the insurance industry are a little bit detached from the reality of the typical consumer applying for insurance. So I'm going to take you to number 23 railway cuttings in East Cheam, where the proposer, somewhat reluctantly, is sitting down in front of his computer to obtain some quotations for their insurances. But the trouble is most people are pretty ill prepared for the task. And instead of collating all the information they need, they quite often embark on guesswork. So they'll guess just to get an indication of premium. They'll guess about modifications to a car. They'll guess they're building some insured. They'll guess the annual turnover of a business. They'll guess about past claims. They'll guess about the dates of speeding endorsements. They'll guess anything just to get the quote. All they want initially is to get some idea who's the cheapest and what sort of money am I going to have to fork out.
Yeah.
Now, this is where the statement of fact, if it works well, acts as a safety net. Because it's all very well doing what is not much better than a dummy application. There's not much point in that exercise unless there's an opportunity to go back and check the information. And this is where the statement of fact can be put to really good use. It is a safety net. You will have heard Roger and me say this before, but we have a real concern that many statements of fact, which are usually emailed these days, go unopened and unread. And so in the process, those policyholders are denying themselves the use of the safety net. They're denying themselves that opportunity just to make sure that their original assumptions were correct. And it's so easily done. You guessed that you had a break-in 6 years ago, but in actual fact it was 4 years ago. And that can make all the difference if the insurer wants to know about claims in the last 5 years. So this is the reality, and it's just as well, I think, to keep this in front of us. It's not the scope of today's webinar to improve the chances of the insured actually opening the attachments to his email, but we have said it before, and we think it would be good for the insurance industry to think of ways in which they can communicate these things and the importance of them a little bit more clearly. Let's look first of all at consumer insurance. So most of us will be familiar with SIDRA, and the general principle is that the consumer must exercise reasonable care in considering the questions posed, or indeed the statements that appear on the statement of fact. Now, the two paragraphs at the bottom here, they're not taken from SIDRA. When SIDRA was only a bill, the law commissioners provided some notes to help the reader to understand what the changes were all about when this was a new law. And so it's explaining here that Clause 2 of the Act abolishes the duty of disclosure in consumer insurance contracts. So what Roger was covering in his opening remarks about the need to disclose every material circumstance is changed by SIDRA, but only for the non-business applicant. And it's replaced with a duty to take reasonable care to make, not to make a misrepresentation. So this removes the consumer's duty to volunteer information to the insurer. And consumers are required to answer insurers' questions honestly and to take reasonable care that their replies are accurate and complete. So in relation to the statement of fact, the insured's only duty is to consider the questions or the statements and to establish whether or not those have been answered correctly. Now, of course, the insurer, if the insurer feels at the claim stage that there has been a misrepresentation, in other words, one of the questions has been answered incorrectly, it's open to the insurer, in fact, it's the duty of the insurer to show that the insured has been at least careless in providing the wrong information. But of course, it's one thing to say that the insurer was careless, but if the questions or the statements have not been posed clearly using good English at the outset, then it might be a bit harsh to accuse the insured of having been careless. And this is why the wording, particularly in consumer insurance, the wordings of the statement of fact have actually got to be absolutely bang on. And the Act has something to say about clarity. So these are words from the Act itself. It says, in assessing whether the consumer has taken the required care, the following must be taken into account. First of all, how clear and how specific the insurer's questions were. Well, that you might think is fairly obvious, but there's another section here which sometimes is absent, because we also need to consider how clearly the insurer communicated the importance of answering those questions or the possible consequences of failing to do so. We find sometimes that explanation just isn't there. So if you take the example of a question which is asking the proposer, what is the rebuilding cost of your buildings? You might say that's a fairly straightforward question. The better application processes will point the proposer in the right direction if they want to check up on how to calculate their rebuilding costs. But it's also necessary, if you look at the wording in the Act here, for the insured to provide enough information for the proposer to understand what are the implications of getting it wrong, which in the case of assessing the sum insured opens the way to an explanation on what happens with underinsurance, the application of average and so on. So that's the regime for the consumer. Roger, could you just run through then the regime as it applies to non-consumer contracts?
Well, yes, I mean, it goes back to really what I was saying right at the beginning, that what the Insurance Act says, you've got to disclose every material circumstances which the insured knows or ought to know. And the problem is, and we're seeing this from the point of view of dealing with people who've been caught out. There are quite a lot of things about an ordinary risk that the owner doesn't know that they know. And we've got a case at the moment which is quite interesting, and this is a subsidence matter. And the owner, who's lived in the house for 14 years, didn't know that the house had been previously underpinned 21 years ago. Now, you can say all kinds of things about, oh, they ought to have known, but they didn't. And actually, having looked at why they didn't, it wasn't brought forward through the legal chain. Solicitors didn't pick it up. It wasn't that important to anybody at the time, apparently. The insurers paid the cost of it. But anyway, what happened is that after a while, something else was built on the same land, and it caused further subsidence. And actually, it's more or less made the original house uninhabitable. And the argument is, oh, well, you didn't tell us that it had been underpinned before. And if you had, we wouldn't have accepted the risk. Well, this is disclosure. This is the kind of penalty that you can have when you take these things.
Roger, isn't there a potential conflict between the terms of the Insurance Act and the practical application of a statement of fact? So
Yes.
let me explain. So we've covered the fact that under the Insurance Act, there's a general duty to disclose information that the underwriter will be interested in.
Yeah.
But then, of course, there are specific issues, usually, which are covered either by a proposal or a statement of fact. So let me give you an example. You might have a business where a company director has had 2 or 3 CCJs, county court judgments. And he's not disclosed those at the application stage. And he's noticed on the statement of fact that, unusually, that there's no question asking about CCJs. So he makes the presentation of the risk, and then the cover is secured. But then at the claims stage, when the loss adjuster is investigating the background, the loss adjuster discovers that there have been 2 CCJs.
Yeah.
And the insurer raises this as an objection. So on the one hand, you've got the Insurance Act requiring a full and open disclosure, but then you've got a statement of fact that hasn't actually asked about CCJs.
Well, this goes to the root.
This is where I see there's a conflict. So how do we resolve that conflict?
Well, I don't know. I mean, it goes to the root of the problem, because I think the majority of policyholders would say, well, why do they need to know about that? It was a long time ago, and it's nothing to do with the risk. Now, we all know as insurance practitioners is that it is something to do with the risk. But the point I've made time and time again is that unless the insurer in the question sets directs the mind of the proposer to the kinds of things that they want to know, then the chances of the average policyholder recognizing that for themselves is somewhere between Bob Hope and no hope. It's not going to happen because people don't understand how insurance works. They don't particularly want to understand it, they just want the price. So I think that when we get to the stage of statements of fact, if statements of fact also leave out the things that the insurer is going to rely upon when it comes to a claim, or confirming coverage rather than the claim, that's a lacuna, isn't it? That's a big gap in the trust relationship in the whole disclosure issue. You can't expect somebody who knows nothing about insurance to know what every material fact would be to a prudent underwriter, any more than a prudent underwriter would know everything they need to know about what any of their insured's technical jobs are. It just isn't going to happen. I think that's the point we're trying to close.
Would you agree, Roger, with this principle that the wording of the statement of fact can be taken by the insured as being a fair indication as to exactly what information the underwriter is looking for?
Yes, it can.
And therefore, let's have a look at some examples, because this is where it comes to life a little bit. So we've actually used this example once before, so those of you with a good memory might recognize it. So here we have a statement of fact where everything is phrased in the negative, so that there are a series of statements, and the insured is invited to answer yes or no. But the problem here is that each of these statements is posed in the negative, and we can very easily get into the problem of double negatives, which provide the opposite answers to those that are intended. And we've often said that it's much better if statement of facts avoid using these negatives. And of course, if you look at this example, it's even more confused, because you've got 4 statements there. The first one ends with a question mark, and the others end in a full stop. So the first one, this property has not previously suffered from subsidence. And of course, in common parlance, you could well see an insured just putting, no, I've not had subsidence. Or if you take the last one, this property is not erected on May ground. It'll just put no.
Well, you could say, yes, it isn't. You could say, yes, it isn't. Couldn't you?
But,
the point is, it depends how you interpret it. Yeah.
So
yes,
it's involving a bit of verbal gymnastics, which could easily be avoided. And this is also an example of just plain bad English, because if you take the second one, neither this, it should be nor any adjacent property to help emphasize what you're saying. It's neither nor, either or neither nor. So we feel that this is just a confusing way of putting the information in front of the proposal. So I think the message on this one is don't use the negatives.
And don't combine questions
Roger,
with statements.
Yes. I mean, much better to just ask the question: is this property on May ground? But we also give some other suggestions in our fact sheet, which will be available after this webinar. Roger, this is an example of a business application. Could you run us through this one?
Yes. Well, they owned and ran a retail clothes shop, formed a limited company, Jones Clothing. Mr. and Mrs. Jones became directors, both experienced in business with previous involvement of directors of other companies. Now, one of these past businesses, for which Mrs. Jones was a director, experienced financial difficulty and went into liquidation. What is the duty of disclosure? Mike.
Well, here is the wording of the statement of fact. So just have a read through that and see what you make of that. This is a very common sort of wording. You will see it all over the place. So we're not picking on any one particular statement of fact or any one underwriter. This is quite a common wording. So it's reasonably clear that what the insurer thinks it's asking is, have there been any past insolvencies that we need to know about? Now, in this case, there was no disclosure of this past insolvency on the part of Mrs. Jones. So the question is, should she have disclosed it? Well, reading through, it says, no proposer, director or partner of the trade or business or its subsidiary companies, either personally or in any business capacity, has ever been declared bankrupt or insolvent or been the subject of bankruptcy proceedings or insolvency proceedings. Now, what we need to remind ourselves of is that where you have a limited company, the limited company and its directors are entirely separate entities. Clearly, there's a connection, but they are separate entities. So in this case, Mrs. Jones read that wording and she said, well, actually, my previous business, which has got nothing at all to do with the business currently being proposed, my previous business, yes, that went into liquidation. So that previous business had been involved in insolvency proceedings. But I wasn't. As an individual, I was not. In fact, as an individual, I can't go into liquidation. If I've got financial problems, I become a bankrupt. But I was not made bankrupt, and I did not participate in insolvency proceedings. The company of which I was a director did, but not me. Now, this all boils down to whether, as a director of a company that goes into liquidation, are you as a director actually involved in insolvency proceedings? And we could debate this for an hour or so and not necessarily come to a conclusion. You could argue this either way. You could put up a fairly strong argument to say that, to be on the safe side, that insolvency of a past business should have been disclosed, but you could easily argue the other way. And the point at issue here is that if a statement of fact that is drafted by the underwriter is unclear, then the ambiguity will have to be interpreted against the underwriter. So should Mrs. Jones disclose the insolvency? What advice would you actually give her?
From a pure insurance practice point of view, I think we could make the case that what the insurer was trying to find out, had Mrs. Jones been involved in a business that ran into financial troubles, and particularly if it went into insolvent liquidation, because it'd be difficult to say that that isn't a material fact. But that's not what the question says. And it comes back to what we said earlier, which Mike and I often hang our hat on, frankly, when in real life, is saying, look, you hadn't directed the mind of the proposer to the question you were really asking. And therefore, we would plead waiver. We'd say, well, you've lost the right to ask it now, because it wasn't sufficiently clear that any ordinary person who was being careful and not careless would have understood what you mean, because they don't understand why the relationship between Mrs. Jones now and the relationship between a company she might have worked for, she might have been a director, it might have been, a statutory director, it might have been a, nominal director, it might have been a junior director. She may have had no involvement at all. If we want to know things about Mrs. Jones' past life in previous companies, let's be specific.
Right, Roger, could I ask you to put yourself in the role of the broker?
Yes.
Who is faced with that statement of fact wording, and the broker has very little, if any, control over the wording of a statement of fact. But knowing of the ambiguity and knowing that Mrs. Jones had been involved in this business that got into liquidation, how would you advise the broker to tackle that?
Well, I know how some brokers do tackle it, because, as you know, we've seen it. And some of them have taken the trouble to work out for themselves two things. First of all, the things that apply to a company, which is the insolvency administration and receivership, and the different types of it and the various arrangements. And the other aspect, which is the things that apply to the person, the director, which are usually CCJs and the ignominious status of bankruptcy. But these things shouldn't be put into the same question. They should be separated. So it's quite clear. And what some brokers have done have made a really good effort to set this out to the client and say, now look, what the underwriter wants to know here is, have you been involved with a company that has failed in the last 5 years or 10 years, whatever it is? And and have that dialogue. One of the most important things that a good broker does is to inject a dialogue into that. But I think that I would say that this particular question is just beautifully horrible. It doesn't direct anybody's mind to anything, and it's so short and it's curt, and the answer is likely to be the policyholder, sorry, the proposer says, "Nah, not me, nothing to do with me." And that's where we start with the problem, because when we're faced with it, we understand from practitioner point of view why the underwriter did have a reasonable reason to ask a reasonable question concerning, if you like, the moral hazard that goes with past financial experiences.
Well, we've had a go at producing a better wording, haven't we?
We have.
Nobody asked us to do this, but
something we made earlier, Mike. Yeah.
So if you look at the middle paragraph there, within the last 5 years or however many years the underwriter is interested in, have you or any director or co-owner of the present business been a director of any company or limited liability partnership which went into administration, involuntary receivership, or insolvent liquidation?
Yeah.
We believe that's a perfectly clear statement of what the underwriter is looking for.
It directs the mind of the proposer to what the underwriter wants to know, and then it's more difficult. It's not, and it's more.
But this is the problem. This is the problem. A lot of these wordings on statement of fact look convincing until you actually start reading it,
analysing. Yeah. Okay.
So let's look at another example.
Yes.
This is an application for consumer insurance, and it applies to you or anyone usually living with you. So this is not unusual. They want to know if you've been convicted or charged with, but not yet tried, or given an official police caution in respect of any offence other than a motoring offence. Convictions regarded as spent by virtue of the Rehabilitation of Offenders Act do not need to be disclosed. So, again, there's a little bit of the negative creeping into this, but generally speaking, we don't have a problem with this because the insured is invited to either say agreed or disagreed. Going down onto the second one, previously had any proposal for insurance declined, renewed, refused, insurance cover cancelled, or special terms applied. Now, again, that's not unusual. We quite often see that on statements of fact. But an interesting discussion point is this, that quite often on an insurance proposal, the insured has got a duty to disclose, for instance, a past policy that was voided forever. There's no cut-off point in this question. So it's not within the last 5 years or even within the last 10 years. As things stand with a wording like this, a voided policy will always have to be disclosed. And if you compare this to the previous question on convictions, where spent convictions do not have to be disclosed because there's an Act of Parliament that says so, we don't think it's quite right that the penalty for a voided policy is more severe than it would be for a convicted criminal. And we know that there are some within the industry who are addressing this in the hope that this can be corrected, because it just seems a little bit too onerous to have to disclose a cancelled or avoided policy for the rest of your life. It's a life sentence. The third one, Roger, would you like to give us an interpretation of the third question here?
No, not really, because it's difficult. Ever been declared bankrupt or been a director of a company that is... A company can't be declared bankrupt. It can only be a person. So what this immediately says to us is that it's been written by somebody that kind of knows what they're asking, but they're not really sure. And these questions really ought to be you recognise that a lot of people that are answering these questions, they don't really understand these subjects any better than some of us do. And not
So
everybody in the insurance market will know. Sorry, go on.
well, Roger, what do you think of this? Bearing in mind that this is an application for consumer insurance, it's not business insurance.
Yeah.
So it goes on to say, declared bankrupt or insolvent that has not been discharged.
It
What
was
does that
bad
mean?
English, isn't it? It doesn't make sense.
And then it says, or ever incurred any IVAs or CCJs. Does that bit apply to the company or to the individual? Because it's all rolled into one sentence.
Well,
There's
it's all
no
rolled into one. I've
punctuation there.
no idea what the underwriter had in mind. But also expressions like IVA and CCJ, a lot of people wouldn't know what they are, particularly if they've never been involved with one. So how are they supposed to answer that question? Because it would be polite, wouldn't it, at least to write it out in full, what it meant, and also possibly to put a footnote in the document to explain what they are and how to recognise one. So I think that it's thoroughly inadequate.
I think we'll put this one down as a fail, if
Sure.
only because of a very poor use of English.
Yes.
This is our last
Do
example
example
for
4.
now.
Hmm.
Yes. Can you run through that one for us, Ross?
Well, this is another one for home application, a home insurance application. It says the property is free from subsidence, free from underpinning, free from flooding, and you can see the answers were put in there were yes, yes, and yes. Then free from watercourse within 400 metres. What does that mean? Free from a watercourse within 400 metres. And the answer was no. Actually, we now know they meant yes. In other words, there isn't a watercourse within 400 metres. But why not ask the question? Why not ask the question that is there a watercourse within 400 metres of your property? Now, we've got a famous case on this, Mike, haven't we? The house on the hill.
Yes, we have.
Which some of you will remember, but this was a case of a house way up a hill on a Welsh hillside, and the river was running right down sort of, I don't know, quarter of a mile away and below. But as the crow flies, it happened to be just within 400 metres. And there was no way that an ordinary policyholder was going to go out with a tape measure and measure what it was. It was a bit of a guess, as we've said earlier. And it was the surveyor eventually that went out and said, well, technically this is within 400 metres. So the insurance company, who wasn't an English insurance company, said, well, I'm not paying that, don't have to pay it. And these people lost £100,000 just because it wasn't there. They were one of, 20 people, I think, in a road that were flooded. And they were the only ones that didn't get a payout from their insurance. And the loss adjuster actually said to us, he said, the whole of the country would have to, or the whole of Wales would have to flood for this house to be flooded by that river. And the point about it is that we've got questions like this. And his problem was exactly the same. He'd been asked a question and he got the answer the wrong way around. And that was it, dead. And I think that this is the problem. We're trying to be very clever in the insurance industry, particularly with InsurTech, in shortening the journey, if you like, taking some of the friction or time and cost out of getting proposers information out of them. But I think we're doing it at the risk of losing even more confidence of the insuring public when they are asked questions which are ambiguous or can be misinterpreted or reinterpreted, when actually it is so easy just to ask a straightforward question and say yes or no. So you're looking at somebody here who is not actually a great convert to statements of fact, because I've seen more problems with them in my years doing this than I ever did with proposal forms. I think that's a point just to sort of take away and consider. I'm not suggesting the market's going to walk away from statements of facts. It won't. But I think we have to live with the consequences of not getting these statements much, much clearer.
Roger, previously you made reference to the principle of waiver.
Yes.
And it might be helpful at this stage just to spend a moment to consider what is meant by that, because there have been a number of judgments in the courts on this very issue.
They
And
have.
if I've understood it correctly, I would explain it like this: that where an insurer on a statement of fact has phrased a question or a statement in a limiting way, in other words, it's the way it's construed.
Yeah.
For instance, on the insolvency issue, you could say that was a limiting question because I've asked quite a detailed question that didn't specifically ask about past directorships of past companies. So I would describe that as a limiting question, and quite often the courts will support the assertion that that opens up the way to waiver. In other words, the insurer has waived its right to information over and above the precise question that's been posed.
Yes, I mean,
Now,
fundamentally, waiver is a doctrine. It's a sort of an equitable doctrine in law that is rarely used. I have to say, it's not something which I think, certainly in my experience, the courts run to all the time. But it does give them the right to say, look, you didn't make it clear what you were asking, and we're going to remove from you now the opportunity to rely upon something that you might like to have asked but didn't ask. I mean, that's fundamentally what waiver does. And in fact, there is a case. I'm just looking at my notes here because I wrote it down the other day. But there is a case. It's called Clarendon Dental Spa, Leeds Limited versus Zurich, and it's a very interesting case about how dental practice was described. And we're not going to go into it now because it would take at least 10, 15 minutes to summarize it. But it's worth, if you're interested in that kind of thing, I know it's probably about 20 pages, I think. But it's the kind of thing we're interested in because it actually is very helpful to see how, when these things do go to court, how the courts take a view which, to our mind, is usually fair and reasonable. So say, well, what was the intention here? How did it pan out? And should the insurer be able to rely upon something after the event that they hadn't thought about before the event?
so
That's what
if anybody
we're
wants,
dealing with. Sorry?
if anybody on this webinar would like to do some research on the subject of limiting questions and waiver, we would recommend a read of that case. So it's Clarendon
Really good, very clear.
Dental. And if you would like us to send you some information on that, let us know. I'm sure we've got some questions to address, but just before we do so, I'd just like to make a passing reference to the role of the broker, because we did touch on this before, but it would be good for the broker to cast their eye over the statement of fact wording so that they could be ready to advise clients how to avoid what we would call the disclosure trap. But there's one other issue, that the principle of limiting questions and waiver can be used by those clients who have got a checkered history, who don't want to disclose things like past insolvencies. And there is a possibility that they could go shopping around from insurer to insurer to find the vaguest statement of fact that they can find, so that they could try and take advantage of the situation. And that's not in anybody's interest. Not in the broker's interest, not really in the insurer's interest. It's not in the insurer's interest. So it's for reasons like that that we're very keen that we could achieve greater clarity in the way that these documents are put together.
Yes, we have done some work on that recently, Mike, haven't we? Which we're discussing with various people. But I think it's terribly important to recognise as a broker that if you have knowledge that some proposal forms ask less clear questions than others, and you use one for the purposes of not disclosing something which you ought to know ought to be disclosed, I would say that it wouldn't be probably the best thing for you to do. Shall we do some questions?
Thank you. And as usual, we've got quite a lot of questions in going on.
Yeah.
But I'd like to take you right back to the beginning and to ask you, how do you change the culture of insurance being sold on price by brokers as the insured trusts their advice, and then when claims are made, they discover they are not covered for the specific claim?
Can you just read that again? Because I think there are about 3 questions in that, but let's just hear it again.
How do you change the culture of insurance being sold on by brokers as the insured trusts their advice, and then when claims are made, they discover that they are not covered for a specific claim?
Well, I think that's probably the golden question of the time, isn't it? How do you capture that trust? The point is, if you're not honest with your client, you can't expect them to be honest with you. And one of the things that the Insurance Act did was to remove the doctrine of utmost good faith, but it didn't remove the principle of good faith, because it actually says so in the Act. It isn't removed, but a lot of people think, oh well, good faith has gone out the window. It hasn't. And the answer to the question, how do you change it? It's got to be something that the industry wants to do. And my fear is that AI is going to trump any views that the industry may or may not have had, because it will be expedient to remove the human interface from the insurance industry within the next 10 years. And I think
Roger, could I just add that at the heart of this question is, how do we change the culture where the buyer is really only buying on price? And,
well, I think
this is the problem, isn't it? That
it is a problem. Yeah.
Insurance is not perceived as having any value.
No.
You know, if you're thinking of going out for a meal on your birthday, you will choose your restaurant, but you won't just automatically go to the cheapest restaurant. You might willingly pay a little bit more because you're going to get an increase in quality. But that doesn't seem to apply in insurance. And I think it's up to us in the industry to get that message across.
Well, I think, Mike, the problem is with insurance contracts, there's nothing to measure until you have the problem. You know, you can read an insurance contract, and most people don't, but you could read it and still be none the wiser. I mean, you and I spend our life reading policies, you know, lots of different policies, and hundreds of them. But actually, we could never say on any policy we've ever dealt with that with certainty it covers a particular thing, because there's always somebody who says, oh no, but I disagree with you. And it comes down to actually the good faith of the insurer and or the loss adjuster and or the lawyer of saying, well, actually, this claim is near enough to what was intended. Although we can take a policy point, we won't. Now, I know a lot of insurers do that. You know, they do say, oh, actually, well, that's okay. Of course, we only see the ones where they don't. But I don't know how you're going to get that message across unless you do it in some kind of constant online advertising campaign like they used to do back in the 60s and 70s when they, you know, I remember who it was that advertised the comfort of the insurance company around you or something. But what we need is a dissertation on how insurance helps you and how to choose between one policy and another. And you can't do that on words.
We're going to take another question.
So why isn't the use of various databases such as Q, My License or LexisNexis NCD for motorists made compulsory for insurers and brokers?
What was the first part of that question?
Why isn't the use of various databases?
I
don't know. Actually,
well, this is an issue that we did actually cover on a webinar with specific reference to the claims and underwriting exchange.
Yeah, we do.
which incidentally doesn't apply to all classes of insurance, but it applies to all motor and certainly, I think, all consumer insurance. So, for instance, if you take somebody applying for insurance and the statement of fact says, have you had any claims within the last 5 years? And they say no, because they'd overlooked a claim that was within the 5 years. They thought it was outside. They could find themselves at the claim stage having their policy voided for a misrepresentation. How did the insurer discover that past claim? Is because they looked on Q. But our position is that that database can be just as easily interrogated at the inception of the insurance as it can at the claim stage. It's just as easy. And in fact, under the Insurance Act, it could well be construed as being information that the insurer already knows.
To an underwriter.
All they've got to do is press a button to get the information. So I think the questioner has highlighted this issue. And in our view, there should be more interrogation of databases at inception and not just at the claim stage.
Yeah.
So we've got another question, and it's actually quite a few questions in one. So it is just to warn you. So is it fair, reasonable, and legally enforceable to ask statements of facts with timelines going back indefinitely? And then following on for that, would the response even be material? And just saying your example of a director liquidating an unrelated company several years before, what would the courts likely decide?
Well, let's take that bit of the question first. It is impossible to say what the courts are likely to have decided without knowing all the facts, right? I mean, it just is impossible. But I think that let's go back to this. The purpose of the question in the first place about past insolvencies or financial irregularities is to find out whether there's a moral hazard in the present risk. Now, if we have a principle of spent convictions, which we do, the question is, in the ordinary way of looking at life as an underwriter, do you really want to know what has happened in the last 5 years with regard to this company, or the last 10, or the last 20, or the last 30? Now, we did a case of about 3 years ago where it was a very big company, but not an international company, but a big British company. They had a serious meltdown 28 years ago. It is now 28. It was 24 at the time. It was 4 years ago. So 28 years ago. And the issue came up as to why they hadn't disclosed this meltdown of 24 years before. And the answer was from the FD, I didn't know about it. And he didn't know about it because actually the company was quite clever in what some people refer to as phoenixing, i.e. closing down everything with the bad news and re-emerging with something else. But in legal terms, there were sufficiently what they call close nexuses, close relationships between the former one that was buried and the other one, that there were some connections there. Now, the present FD has been in place, I think, only 2 years, and just hadn't come to his notice, and there's no reason why it should. But it was relied upon in this case to say this was a gross misrepresentation of material fact, and the rest of it was history. And I think the point is this, that if you're talking of a consumer insurance, you probably don't need to go back 30 years for anything, do you? If you're talking of something as big as what I've just described, there may be reasons when the underwriter says, I genuinely want to know about the past history because I think that it would affect my judgment as a prudent underwriter. But you can't have a system where we have sort of what I call rolling one-size-fits-all questions to answer a problem like that. It just doesn't work. So the answer is what's fair has really got to be related to the circumstances of each and every case. But I think in principle, the way out of this would be to insist, and I'm saying this as an ex-broker, to insist that the underwriter gives a period. And if he says, no, I want it to infinity, probably go to another underwriter, unless there's a really good reason for wanting to know. Because I think the insured is entitled to that degree of certainty in their contract. I think that hope that addresses it. Mike, you got anything to add?
No.
Should we do another question?
Lovely. So can you comment on the nuanced issue of how sole traders, who might be considered consumers in some contexts, are treated under non-consumer insurance contracts?
Oh, golly, that's a big subject. Mike, you'll go.
Yes, you might think it's a cop-out to say it depends on the circumstances, but this commonly crops up with private individuals who insure a property which is a buy-to-let. So are they doing that in their personal capacity, or are they taking out that insurance in the context of a business? And more often than not, that would be construed as being a business. I believe that the intention of the difference between consumer and business is that consumer insurance should have no business application. And I think if you take that view, then that's the safest.
Yeah. Yeah.
So we've just got a question on asking if we can be reminded why we moved away from proposal forms, which would then drive a statement of fact relevant to information provided, or, triggering further investigations or questions.
Well, why we moved away from them, I think, is a question that you could put out to everybody and see how many variations of answers you get. But fundamentally, I think most of the things that we've seen change in the industry have been driven by time and cost, money. In other words, how can we reduce? The other reason is this, that the remedy for insurers before the Insurance Act were getting increasingly uncertain when they wanted to say no to a claim. And one of the things that does help a lot is if you make a statement of fact, you are making, effectively it's a warranty of the truth of the situation, which has more power in law than the answer to a question. Now, it's a lot more technical than that, but that is fundamentally. So I can see why, as an underwriter, there is some degree of safety net in making a statement of fact. And I'm not going to say that that's a bad thing. I think underwriters need the protection against those elements of society that are determined to commit a fraud or dishonesty against the insurer, and there are some, we know that. And I think that is reasonable precaution to take. So I think that when the first answer, I think, is that it is cheaper to tell the insured what you want to believe than it is to ask him a whole load of questions. And I've seen proposal forms over the years get shorter and shorter and shorter, and now they're almost... In fact, we've got a case at the moment where there is no proposal form and no statement of fact. I mean, how they went on risk, I don't know, but it was quite a big insurer. They must have had some reason for saying, well, we'll do that, back of an envelope. I think it's bad practice, fundamentally bad practice, because if the insured doesn't know what he's supposed to have told the insurer, then actually you could say there isn't a contract in the first place. But when you have a big claim, that's the last thing you want to hear, because all you do is get your premium back. So I think the answer has got to be, we need to revisit. One of the reasons we've done this webinar is because there's enough things wrong with the SOF to look at it again on the basis of what are we trying to direct the mind of the insured to? How clear are the questions so that the principle of waiver doesn't get brought into play, and what can we do to attract the integrity of our industry to the people we want to sell to. And the best thing to do is say, this is what we want to know, this is how you're going to tell us. I would actually still have a whole question set with proposal form. I wouldn't mind putting a statement of fact behind it, but I don't think it should be just the statement of fact when the insured has really got no idea what they've said and what's being relied upon. I think it's just unfair.
Thank you. That's really informative. We've run out of time, unfortunately, and just to let you know that questions will be answered following the session that haven't been possible to be answered today. So Michael and Roger, I think you've got some work cut out for you this afternoon in getting through those questions.
Yeah. Can I just say before you go, we've got a very full fact sheet on this one. There's quite a lot to say. And in fact, on the last one, I think Mike was a pretty full fact sheet as well. Because what we're trying to do is to capture in our fact sheet things we haven't got time to say in the webinar. But
that will be made available to everybody.
It'll be made available. Yes, absolutely. Anyway, sorry,
it's just up to me to say. So it's just up to me to say thank you both for delivering the webinar today and for all the information that's been shared. This session will now be available on demand, and please feel free to share the webinar with anyone you think would benefit from it. Your CPD certificate and a copy of the slides will be available to download from this portal. And just like to say a big thank you to you and all the delegates for joining us today. Goodbye.
Bye-bye.